Welcome to another After Hours 3-minute news break. The episode bringing you the major employment and regulation changes that occurred over the last week. Let's get started with the Crown Act. On March 18th, the U.S. House of Representatives passed the highly anticipated yet partisan Crown Act, which stands for Creating a Respectful and Open World for Natural Hair. The Crown Act prohibits employers from discriminating against their employees on the basis of their natural hairstyle. For example, many Black Americans cite to instances of being treated unfairly via discipline or an employer's policies for having braids, knots, or twists in their hair. This act would prohibit such horrible discrimination and would prohibit such policies against these natural hairstyles and further protect these minority employees in the workplace. Some states already have state law prohibitions against hair discrimination, but there's no national prohibition. President Biden is fully expected to sign this bill into law if the Senate passes it as well. Although there was bipartisan support in the House, a number of Republicans voted no on the bill, so it remains to be seen what the Senate will do. Of course, we will bring you updates on the Crown Act and its requirements as it flows through the legislative process. Next, let's jump into the world of the EEOC. The EEOC recently updated its questions and answers regarding religious accommodations for the COVID vaccine. The EEOC clarified that employers may ask their employees to explain why religious beliefs are impacted or in conflict with the COVID vaccination requirement. Essentially, the EEOC is requiring employees to specifically explain how their religious beliefs would be impacted if they were forced to get the COVID vaccine. The EEOC hopes that this will better help employers separate political from religious beliefs when determining whether an employee's beliefs are truly those that warrant a religious accommodation. In addition, the EEOC stated that a reduction in pay, such as an unpaid leave of absence or loss of benefits, may not be reasonable accommodations if there is an alternative that allows the employee to keep their usual pay and benefits. Accommodations such as testing or different mask wearing or working from home that would allow the employee to remain unvaccinated and yet still get their same pay and benefits. This is the biggest clarification from the EEOC on religious accommodations to date. For employers that got used to simply giving unpaid leaves of absences as accommodations, you will need to reevaluate this process ASAP. We will have a future, more in-depth episode on this issue, especially as booster shots become a hot topic again with the rise in new COVID variants. Finally, let's move into President Biden's new executive order on pay analysis. On March 15th, President Biden issued an executive order for rules to be implemented that would prohibit federal contractors from considering a job applicant's or employees' existing or past compensation when making employment decisions. At this time, nothing changes for contractor employers as the rules still need to be written through the Department of Labor, but they will likely come very soon. The issuance of this rule comes on the heels of the nationally celebrated Equal Pay Day. Essentially, this matter typically arises when an employee is given a lower pay compared to their counterpart. These rules have the potential to prohibit federal contractors from inquiring from an applicant or an applicant's prior employers about their rate of pay at their prior positions. More information will come from us in these regulations in the near future, so stay tuned for that. We really appreciate you staying tuned to this Employment Law After Hours news break, the channel bringing you the issues that keep HR professionals up at night. I hope you all have a great rest of your evening.